Okay, good morning, everyone. My name is Ben Slang, and I'm the Membership and Business Development Associate at the Digital Supercluster, and I am pleased to welcome you to our webinar, Innovating in AI Through a Regulatory Landscape. Before we get started, we respectfully acknowledge that in Canada, we live, work, and learn on the unceded, traditional, and ancestral land of Indigenous peoples. As myself and much of the Supercluster team are based in Vancouver, BC, we are gathered here on the traditional ancestral territory of the Musqueam, Squamish, and Tsleil-Waututh peoples, and we recognize and we encourage that you take a moment to acknowledge the traditional territory that you are joining us from. As a reminder, this webinar today is going to be recorded and it will be distributed to all registrants afterwards. If at any point you have any questions, please type it in the Q&A and we'll address them during the Q&A portion. And with that, I'll pass it off to Jen from the Supercluster team.
Thank you, Ben. Bonjour, everyone, and welcome. It's wonderful to have attendees joining in from across this country for this month's webinar. Whether you're new or a returning participant to the Digital Supercluster's IP series, we're thrilled that you could join us for this Thought Leadership Power Hour. Next slide, please. There are important and timely considerations in understanding how you can innovate using AI whilst making sure that you're going to be compliant within the evolving regulatory landscape. Over these next 60 minutes, the discussion will center around implementing a regulatory mindset into the technology you're building, understanding the current space, the EU AI Act, US AI Bill of Rights, and Bill 27, what to be thinking about, and the responsibilities that may be imposed by these regulations from a Canadian and global lens, and a Q&A portion to follow at the end. Next slide, please. Fundamental to the global innovation clusters is collaborative innovation, setting the framework for projects that address cross-country challenges while creating technology products and services that can scale across industries and ultimately across the world. Digital's IP strategy supports the development, ownership, and retention of Canadian IP through a number of vehicles, and informational sessions with thought leaders like we've today are one example of that. Next slide, please. I have the pleasure of introducing two industry thought leaders with us. Please join me in welcoming Justine Gauthier and Nikita Stepin. Justine is Director of Corporate and Legal Affairs at Mila, a prominent AI research institute at the intersection of academia, government, and industry. She is responsible for Mila's IP strategy and for providing counsel on the legal, regulatory, and ethical implications of developing cutting-edge machine learning technology. Justine oversees a team of lawyers responsible for negotiating complex collaborative technology agreements with a variety of public and private sector organizations, from F500s to startup and SMEs, in fields that include biotech, software, healthcare, finance, retail, and energy. Prior to joining Mila, she practiced law at a top Canadian law firm. And big congratulations to Justine and the legal team at Mila for being named a 2023 Excellence Awardee in the category of Law Department Innovation by the Canadian Legal Awards. And Nikita, partner at Norton Rose Fulbright, and practices in all areas of commercial technology and intellectual property law, with a focus on corporate and commercial technology-related contracts, including software as a service, technology, sales, R&D, IP licensing. With a strong background in IP litigation before the Federal Court of Canada and the Federal Court of Appeal, he has acted on both sides of multinational mergers and acquisitions, patent purchases and sales, and licensing and IP transactions, and advises clients on compliance with all Canadian privacy and data management laws, cybersecurity breaches, and reporting of data protection. Nikita has particular experience with complex pharmaceutical and medical device patent infringement, and frequently publishes on the Norton Rose Fulbright blog pertaining to recent developments in copyright and patent law. We're in for a treat today. Thank you very much, Justine and Gauthier and Nikita, and I hand it over to you.
Great, thank you so much, Jen. Let me just quickly share my screen here and we can get started. Okay. Hi, everyone. Really glad to be here with you all today. So I'm going to start things off today by talking about a brief overview on the relationship between AI and data over the years. So earlier fundamental AI models were trained on very basic non-personal data. So for example, what many consider to be the first machine learning program was a computer program created by IBM that was able to play checkers. So for example, in this case, the data was previous games of checkers and moves that you can do in checkers. Another example is what is considered to be the first neural network that was invented called perceptron, and it was trained using a set of punch cards. So in this case, the data was essentially actual physical punch cards, and the AI was trained to be able to determine whether the punch card had been punched on the right or on the left. But of course, in the past decades, as AI evolved, the potential applications multiplied, and so the types of data that this AI can be trained on also multiplied. And so the use of personal data in machine learning applications became much more prominent. So for example, today we have AI models that are able to process data from anything from web searches made by internet users, or even in the healthcare sector, x-rays of actual patients. Even today, though, it's important to keep in mind that not all AI uses personal data. In fact, there's many promising areas for machine learning that do not require the use of personal data. An example that I can give that we do a lot of research and work on at Mila is everything in the field of drug discovery. So working with pharmaceutical companies and biotech companies to discover potential new therapeutics. So in this case, the data that's being used is, for example, molecules or chemical structures, so not personal data. And I think this is partly why we're starting to see regulators are no longer satisfied that personal information regulation alone is enough to cover all the risks associated with AI. And that's why, as we're going to talk about a bit later, they are coming up with specific AI legislation beyond just the personal information implications of AI. And so as far as understanding your use of AI, that really begins with understanding your AI itself and talking with your tech teams or with your suppliers. So if we take the main steps that an AI model follows, we have first the input. So what data are you feeding your AI model? And here there's obviously considerations of personal versus non-personal data, the identified data and anonymized data, things like that. There's also a consideration that people sometimes forget of training data versus production data. And what I mean by that is that I might not need to use personal data at the R&D stage, and I can get away with using synthetic data for that stage in certain instances. But once I then take that model that I created using synthetic data and I implement it into my tech stack and deploy it into production, if that AI system is now running on personal data, I need to make sure that I'm going back and adding any additional safeguards that are required in that case. The second step is processing. So how is my AI actually processing the data? And a big component here is explainability requirements. So in some cases, and as we're going to see a little later, that's going to be required more and more with upcoming legislation, explainability will be required. So you're going to need to be able to explain how your AI model works and how it came to a particular conclusion in a particular case. Now, for people like me who are lawyers, that sounds pretty logical and reasonable, right? If an AI model makes a decision about me, I should be able to understand why it came to that conclusion, just as I could ask a human who's making a decision about me to give me a reason for a particular decision that was made. However, from a technical standpoint, it's really not that simple, because a lot of AI models, even today, still function as what we call black boxes, right? So you input data into the model, you get a particular output that you're able to validate is actually correct, but we don't know actually how the AI came to that particular conclusion and how it processed the data to have a certain result. So it's going to become more and more important to be diligent about whether a model you're deploying requires explainability from a regulatory or even an ethical standpoint in certain instances. Something else to consider at the processing stage is bias. And obviously that is a big topic in AI, and we could probably do an entire webinar just on bias in AI. But today, I will say that although bias technically falls under processing, because it's really at that stage that certain biases can be kind of created through the system, it really begins at the input stage. What data are you feeding your AI model? Is the data diverse enough? Does the data contain labels on it that could create biases when it's then processed by the model? So things like that. And then the third step is output. And this is what we call the results, right? What results is your AI model producing, and how are these results being used? So here, a couple key considerations are accuracy. So we're seeing legislators want to impose obligations as to the accuracy of certain high-risk models, high-risk AI models. And we're seeing that in particular in upcoming legislation in Europe, where for certain AI models in certain applications, for example, in the healthcare sector, there's going to be requirements as to a certain level of accuracy and performance of AI models. There's also a big component to the output, which is how are these results being used? So are they just fully automated, or is there a human oversight? And so under upcoming legislation, again, human oversight is going to be required for certain AI systems. So certain AI systems are not going to be able to be just fully automated, and they're going to need an actual human to validate the results and take a second look. And for systems that are going to be allowed under legislation to be fully automated, we're going to see more and more certain requirements around these fully automated decision-making systems. And a good example of that is in Quebec's new privacy legislation. There's a specific section that's coming into effect next September that requires for automated decision systems a right to be informed, a right to an explanation, and a right to a review of the decision. So for example, if I go to my bank and I apply for a mortgage and the bank has decided that mortgage decisions are going to be fully automated, I'm then, first of all, have the right to be informed that actually the decision on whether or not I get approved for a mortgage, decision on my rate, etc., I have a right to know that it's not a human that's taking that decision and it's actually an AI system. I also have a right to an explanation. So we go back to the explainability piece. If I'm not happy with the decision that was made, I have a right to ask the bank, why was I refused a mortgage? What factors came into play? What was considered? What had a lot of weight versus not in a particular decision? And I'm also going to have a right to a review of that decision. So again, if I'm not happy with the decision, I'm going to have the right to go to the bank and say, I want an actual human to review this decision. So this is upcoming in Quebec, but we're seeing things like that really all around Canada and all around the world in those instances. And what we're going to see is that under upcoming legislation, disclosure is going to be required in certain cases, even when not processing personal data. So right now, the example I gave about Quebec's legislation in that aspect is really related to an automated decision made using personal data. But we're going to see a little later that there's going to be requirements of disclosure for cases of AI, even when it's not processing personal data. So with that, I will hand it over to Nikita for now to talk a little bit more about other aspects of the existing regulatory landscape around AI.
Thank you, Justine. So to start off and really get a sense of what the existing regulatory landscape is, it should be said at the outset that Canada does not yet have a comprehensive legal framework to regulate AI. So there's a global trend in AI regulation, which you'll hear us talk a lot about today, which has taken momentum in the US, the EU, and Canadian legislators appear now to be really determined to move beyond general policy frameworks that have sort of been in vogue in the past and which were developed by private and public stakeholders, and really adopt hard law that would be the law of the land with respect to AI system development and use. And as the AI ecosystem moves towards globalization, it becomes more important to track both government initiatives as well as regulatory changes around the world. A common trend, as you'll see, is the international focus on the development of transparent and responsible AI policy that permeates all of these directives and legislation. So in the public sphere right now, there is currently what is called the Directive on Automated Decision-Making, which imposes a number of requirements primarily related to risk management on the federal government's use of automated decision systems, which is the term you'll hear us use a lot, as that's sort of how it's referred to, how AI systems that are regulated are referred to in these directives and in legislation. So this directive took effect in 2019 and applies to systems used by the federal government departments to provide services to a client external to the government of Canada, as well as systems, tools, or statistical models used to recommend or make an administrative decision about a client of the federal government. So the goal of the directive is to ensure that these automated decision-making systems are implemented with the least risk possible and incorporate principles that are near and dear to the government's heart, obviously procedural fairness, due process, of course, while intending to support and harness innovation and make decisions pursuant to Canadian law. So at a preliminary level, the directive requires an algorithmic impact assessment for each automated decision-making system that is based on certain assessment criteria. Then the assessment leads to a classification of those systems from the lowest impact level 1 to the highest at level 4. And once that impact level has been assessed, the directive imposes essentially different requirements based on the impact level, including core tenets of transparency, use, quality assurance, among others. And as you'll see, these tenets have really been expanded upon and further fleshed out in the ongoing effort to draft and implement AIDA, which is a law you'll hear us talk about that Justin will go in detail, that seeks to establish a more comprehensive AI framework beyond the sphere of government alone. And the final point to make here in covering the existing landscape, as Justine alluded to, privacy law has always been and still is to this day the vehicle of choice to regulate AI systems in Canada. The most significant legal change faced by the AI industry, as you know, is reconciling AI need for large amounts of structured and standardized data with the core human right of privacy. A prominent example that we hear a lot in the news right now is facial recognition technology that's been deployed in cities and airports in the US, for example. And recently, there have been decisions made that in relation to privacy concerns, those systems have been tempered or simply removed in big hubs like San Francisco. And so one point there that you often hear about, no matter where you are in Canada, is the newly introduced Bill 64, now known as Law 25, which has now come in effect as of last year and really profoundly reformed Quebec privacy law, which is a good example of this approach. There are some measures there that are relevant to this discussion in this group, such as transparency requirements for public bodies and private enterprises that make decisions exclusively based on automated processes. It creates obligations on the user of an automated process to explain what personal information was used to render the decision, as Justine alluded to as well. And Bill 64 also creates a general obligation for businesses to perform what is called privacy impact assessments to evaluate projects that involve the acquisition or development of information systems that involve the processing of PI, of personal information. So all of these assessments may be required in certain contexts involving AI systems. And next slide, please. To get a grasp also of why discussions around AI regulation will inevitably touch upon issues of privacy law, it's simply because AI is widely viewed as having an immense potential, right, to impact the privacy rights of individuals. So in Canada, current privacy laws, such as the Personal Information Protection and Electronics Document Act, also known as PIPEDA, at a federal level, was not written at the age of big data, cybersecurity threats, social media, and AI. They were written at the aftermath of the dot-com boom, when the emergence of the internet, the rise of e-commerce. So it's really a different reality that shaped the core tenets of these laws that, of course, now are being questioned and the status quo is being challenged. So PIPEDA, at its core, is a consent-based privacy protection law. So the law contemplates that a service or technology provider, as a collector of personal information, needs to obtain the consent of the user before processing any personal information. So in 2020, the Privacy Commissioner of Canada released a report containing recommendations on how AI should be treated under Canadian privacy law and what protections need to be put in place to ensure a fair balancing of rights. And I think this report is interesting because, as we have been discussing so far in terms of trends, it highlights again some of these key concepts which we'll be discussing today and which you'll see are again at the core of all the proposed privacy and AI regulation reforms. So under PIPEDA, which, as I was saying, was built around consent at its core, for consent to be considered valid, it must be what is defined as meaningful. So the user must have all the right information in order to make the decision about giving consent or not. So at this point, the commissioner writes that AI highlights the shortcomings of the consent principle in protecting individuals' privacy, and that it allows the benefits to be achieved. Consent can be used to legitimize uses that objectively are completely unreasonable and contrary to our rights and values. Additionally, refusal to provide consent can sometimes be a disservice to the public interest, where there are potential societal benefits to be gained from the use of that data. So the takeaway here is that consent as a basis for personal information processing cannot always cope with present-day technology such as AI. And laws must be enabled not to stifle innovation while also protecting privacies. So there are other elements in this report that are of relevance. Just briefly, one is specific rights for automated decision-making systems that must be put in place, with rights to explanation, rights to contest, which, as you're starting to see, are sort of permeating throughout all of our discussions. And there's the concept of privacy by design that is discussed. The point here is that developers must also ensure that AI systems are developed to address privacy concerns and integrate privacy into the operation of the system from the beginning. So privacy cannot be an afterthought or a patch. It must be integral to the offering. The next slide, please. So to touch upon, since we're sort of drawing the history of where we were, where we are, and when we're going, I think it's important to just say a few words on initial reform initiatives and what happened to them. So in November 2020, the federal government proposed substantial changes to Canadian privacy law with the introduction of Bill C-11, which proposed to repeal the personal information related provisions of PIPEDA and replace them with a new privacy and data legal framework. The original text of Bill C-11 also contained similar obligations as the ones we saw in Quebec's privacy legislation, which itself was based on the GDPR in Europe, which you might have heard about. So again, drawing this idea of that there's a global trend of uniformity that is being sought. So one of the elements that Bill C-11 was introducing is the new Consumer Privacy Protection Act, which in its then current form would have implemented a bunch of requirements, including, for example, the need for businesses to make available that businesses' use of any automated decision systems to make predictions, recommendations about individuals. I say would have because the initial effort did not lead to anything. The bill was dead on the floor and it never made it into law, partly because a federal election was called in 2021. However, as you'll see, as Justine will get a little bit into C-27, the new bill that is now on everyone's lips, what was then in C-11 was quite limited compared to the specific and standalone AI provisions we now see under AIDA. In Bill C-11 would have only regulated automated decision systems with a limited number of privacy law sections, whereas now the legislator is willing to go much further. However, what is interesting here is that in addition to introducing AIDA, as I'll be talking about later myself, Bill C-11 also reintroduces the CPPA. So it'll be interesting to see the interplay between these two proposed federal regimes, one standalone regime for AI systems only, and one for automated decision systems under the privacy lens, since, as you'll imagine, there will definitely be overlap and potentially conflicting obligations and outcomes. Next slide, please.
All right, so before we dive into more detail in what is upcoming in terms of legislation, I do want to address the ethical use of AI, which I've touched on a little earlier, and what's applicable to that as of today in legislation. So currently, ethics of AI itself are not directly addressed in legislation. However, a lot of organizations are taking steps towards ethical AI, and we're seeing that a lot in the ecosystem at Mila. We are seeing a lot of both public and private sector organizations really want to look for guidance on how to build and deploy ethical AI because they want to do the right thing, but also because there's pressure coming from investors on that front, and also obviously reputational risks as well. However, in upcoming legislation, we're really starting to see ethics take a center stage position. So for example, in Canada under AIDA, which we're going to discuss later, AIDA is really centered around protection of the public. It's really centered around risks of bias and of harm to fundamental rights. And in the EU, we're seeing they're going even a little more specific. So we're seeing prohibitions of certain AI systems that either intend to materially distort a person's behavior. So think an AI system that intends to influence how a person might vote, or systems that evaluate the trustworthiness of natural persons. So for example, social scoring systems. So those kind of things are going to be banned altogether in the European Union under upcoming legislation. And then in terms of discrimination and bias, there's obviously various existing laws that are applicable to discrimination as of today. Ultimately, a company that engages in discriminatory practices is going to be liable for those practices, whether or not they originate from an AI system, from a traditional software, or from a human, right? So a good example that I like to talk about for this is Amazon. So Amazon created and was testing a system to help them in their hiring. So they had an AI system that would go through all of the resumes of people that would apply for a job at Amazon, and then it would recommend who should move on to the interview stage. Thankfully, the system never made it into actual production, because while Amazon was testing the system, they realized that the system had a bias towards male candidates. So it would recommend that male candidates move on to the interview stage versus female candidates. So obviously, as I said, thankfully, this was never into production, but let's just say it had been, and Amazon did deploy the system, and someone realized that this system had this bias. Well, Amazon could have been liable for discrimination because of that AI system. And we're going to see a little later that draft laws in Canada and the EU do address discrimination by AI systems more directly.
Thank you, Justine. So taking all of those issues, which we sort of flew through, and there are definitely others, but these core issues in consideration, different jurisdictions have gone about differently, of course, in having to find a suitable regulatory framework to address them. So the UK government is an example where it is expected, there's some initial publications that have been done, nothing final yet, but is expected to outline its AI strategy in a white paper that is generally light on coercive measures and on a non-statutory basis, helping it remain quite adaptable. So it talks about removing existing regulatory burdens where there's evidence that they create unnecessary barriers to innovation. There's discussions about retaining existing sector-based approach to ensure, again, flexibility and that individual regulators may be empowered to work flexibly. And it introduces cross-sector AI-specific principles and rules. A more rigid approach, as Justine said, to AI regulation is being adopted in the European Union with the proposed introduction of the EU AI Act, which will categorize AI as being at an unacceptable high or low minimal level of risk. Unacceptable risk include, for example, systems that are subliminal, manipulative, or exploitative and that cause harm, or forms of social scoring, for example, AI that can assess an individual's trustworthiness based on certain behaviors, for example. So there's this effort to regulate these elements specifically. This AI Act is expected to be finalized in 2023. But it may be subject to delays and change, as these things often are. They've also introduced an AI liability directive that allows for companies being harmed by AI to bring claims against the perpetrator. So there are different ways to give tools as well to have coercive measures in place. As for the United States, 2022 saw an initial approach to AI regulation emerge focused specifically on use cases. So Justine just mentioned it, it's definitely something that is being considered everywhere, but a use case most prevalently regulated in AI is in recruitment and employment. New York, for example, has joined a number of states in regulating automated employment decision-making tools that assist or select in candidate screening. So under New York's law, these systems must undergo what is called an annual bias audit with the result that need to be published or made publicly available. 2023, this year, is likely to see some of the first general obligations that apply across AI use cases. Also contained in privacy legislation, as it is in Canada for certain states. At the federal level, in fall of last year, and this is sort of the big ticket item here, the White House Office of Science and Technology published what is called a blueprint for AI Bill of Rights, which shared non-binding roadmap to responsible use of AI. I think for the purposes of this discussion, suffice to say, the principles that are outlined in there are generally aligned with what you've been hearing us talk about. I can read you, there's 5 core principles. It's safe and effective systems, algorithmic discrimination protection, data privacy, notice explanation, and alternative options. So these core principles are meant to orient policymakers in adopting AI reform legislation. The reception to this Bill of Rights has been mixed, with certain groups believing it does not go far enough and does not have the sort of checks and balances and tools that the EU Act has, and so will be ineffective and moot. Others salute the principle of the soft touch approach for now, not directly moving to federal legislation, in order to allow constructive discussions around these principles entrenched in softer policy direction. But the key takeaway, I think, from all of this discussion is that keeping an eye on international developments is important, because, for example, as the EU Act has, there is some extraterritorial application to these laws. And so multinational companies will need to be thinking about developing coordinated global compliance programs. Next slide, please.
All right, so now let's dig into what is going on in Canada. So Bill C-27 was introduced to Canadian Parliament last June, and if passed, it's going to do 3 things. So first, it's going to implement Canada's first and world's second, after the EU, artificial intelligence legislation, which we're going to refer to as AIDA in the presentation. Second, it's going to reform Canadian privacy law by replacing existing privacy legislation, which is AIDA, with a new Consumer Privacy Protection Act. And it's also going to create a tribunal that's going to be specific to matters of privacy and data protection. So I'm going to first be talking a little bit more about the AIDA portion of this bill. So what AI is actually covered by this Artificial Intelligence and Data Act? The definition, as you see here, is quite broad, but what's interesting is that it does scope it down to AI that processes data related to human activities. Again, we don't know exactly how that will be defined, but there is reason to believe that a number of AI applications will be out of scope of this legislation. So for example, I talked a little earlier about work that's being done around using AI to accelerate drug discovery and discovering new drugs. So in that case, the data is composed of things like chemical structures, which is not really something that would be related to human activities, at least from what we can tell so far. So this, of course, remains to be further defined, but it's important. It's an important nuance to keep in mind, because there's a good chance that certain AI systems are going to be out of scope of this legislation. And what we're seeing here again through this act is that the federal government is really more focused on protection of the public. That's really what's at the core of this act here. Now, in terms of the scope of application, again, this is quite broad. So AIDA is going to apply to those who either design, develop, make available for use, or manage the operations of AI systems. ICED recently released a supplemental document, and there's an indication that a higher burden of these obligations will probably be on the companies who are developing these systems. But this really remains to be further detailed in the regulation that's going to come out of AIDA. AIDA also provides for extraterritorial effect in the extent that AI systems are either used, developed, designed, or managed in Canada. So if one actor in the value chain is in Canada, this will likely trigger the application of AIDA. And so in terms of what this actually means and what obligations are going to be required for AI developers, designers, or providers, AIDA follows a 2-step structure. So first, there's obligations that are going to be required for all AI systems. And those include establishing measures to manage anonymized data. So earlier, I said that legislators are no longer satisfied that the personal information legislation are enough. And so this is a prime example. Anonymized data is usually out of scope of personal information legislation, as it cannot be traced back to an individual. However, here we're seeing that legislators want even anonymized data to have some safeguards and best practices put around them. So again, we don't really know yet what that's going to look like in practice, because that's going to be further defined in the regulations. There's also an obligation of record keeping, and that's going to come along with some audit rights and audit powers of the government. And the third obligation is really one of the centerstone pieces of this legislation. And it is the obligation for every AI system to conduct an assessment to determine if that system is high impact AI or not. And again, what is going to be high impact AI has not yet been defined. It's going to be defined in regulations. However, in the recent ICED supplemental document, we do have indications that considerations of health, safety, and human rights will be considered in carving out what is high impact or not. And this is pretty similar to what we're seeing in the EU piece as well. The second step will apply to AI systems that will have been deemed high impact following that assessment. So for those, there's going to be additional obligations that are going to apply, and the main ones are going to be developing a risk mitigation plan and monitoring mitigation measures for the risks associated with that system. There's also going to be an obligation to publish a plain language description on a publicly available website of what the system is, how it will be used, and what types of decisions, recommendations, predictions, or content it can generate. Another obligation will be to notify the federal government of systems that pose a risk of material harm. So this is an even higher threshold here. And again, material harm has not been yet defined, so it's hard to tell at this point exactly what systems would fall under in this category. It's also unclear at this point whether that information will remain confidential at the federal government stage or whether it will be publicly available. For example, in the EU Act, what we're seeing is that there's actually going to be a public registry of high-risk AI systems. So yet TBD on whether that will be the case in Canada as well. Now, on top of these kind of two-step obligations, AIDA also creates obligations in relation to certain specific themes, and a main one is disclosure and transparency. So in terms of disclosure obligations, in addition to the publication of a plain language description of high-impact systems, AIDA also creates a right for people to be informed when a decision that concerns them is made by an automated decision-making system. So this is similar to what we're already seeing in certain personal information legislation. And in terms of explainability, as we discussed earlier, there's going to be a right to an explanation of an automated decision-making system that could have a significant impact on an individual. So again, this threshold is quite high, but for decisions that really, again, have potential to harm individuals, so actual human beings, there's going to be certain requirements that are going to apply in addition to the requirements that are going to be for all AI systems, regardless of whether they impact an individual or a business, for example. Now moving on to the scary slide of the presentation, the fines and enforcement. So there's going to be administrative penalties, but again, that's been left up to regulators to define. There's going to be also criminal contraventions of up to $10 million or 3% of global revenue. But the piece that I really want to talk about, because it's really quite interesting, is that AIDA creates a new criminal offense that's going to be related to making an AI system available for use when that AI system causes either serious physical, psychological harm, property damage, or substantial economic loss to an individual. So again, really focusing on individuals. And what's interesting about this is that this criminal offense doesn't particularly relate to violating a specific portion of the act, right? It's quite broad. And the fines for that are going to be up to $25 million, 5% of global revenues, or in the case of an individual, even up to 5 years in prison. So obviously, what we can see here is that the federal government is really not messing around in enforcing and really putting safeguards around AI and making sure that people actually respect them. However, the reason why I don't want this slide to scare you too much is that ICED has said that in the initial years after AIDA comes into force, the focus will really be on education, establishing guidelines, helping businesses to come into compliance through voluntary means. So they really intend to leave a lot of time before these kinds of fines and enforcement are actually put into place. And now in terms of adoption and implementation process, as I said, this bill was introduced last June. It recently passed second reading. And we do have reason to believe that regulations are expected to come into effect no sooner than 2025. So that is the good news. We still all have a little bit of time to prepare ourselves to what's coming. And as we've mentioned, and Nikita is going to touch on this, it's coming in Canada, but it's really coming in every major jurisdiction, the EU, certain parts of the United States, and eventually federally. So I think this is going to be a really important thing to keep in mind in the coming years when you're developing AI, and really make sure you're ready for when those obligations come into force.
Thank you, Justine. So having seen some of those core elements of AIDA, it makes sense to, I would say, quickly see where they stand in comparison to its other high-profile counterpart, the EU AI Act. There are obviously quite a few distinctions and a lot of similarities, but I wanted to highlight a few of the core ones here, since as we discussed, it's always important to keep bearing in mind that you need to think about these issues on a global compliance scale. And also, this allows to note where there are certain gaps that could be adjusted as AIDA continues to grow and mutate through its as it goes through the legislature and through future regulations as well. So first, while both acts define AI systems relatively broadly, as you've heard Justine discuss, the definition provided in AIDA is narrower. So AIDA encapsulates technologies that process data autonomously, whereas the EU Act does not stipulate any degree of autonomy yet. Both acts are also, of course, focused on avoiding harm, but they define that concept differently. A concept they do define similarly, but there's a distinction in sort of what it includes and what it encompasses. So in the EU, the concept is a bit broader in scope, as it considers, for example, serious disruptions to critical infrastructure as harm, whereas AIDA is for now squarely concerned with harm suffered by individuals. Another point is that AIDA's application is limited by the constraints of the federal government's jurisdiction in our constitutional system. So while, as you've heard Justine say, it broadly applies to all actors through the AI supply chain from design to delivery, it only regulates their activities as they relate to interprovincial or international trade or commerce, which is under the federal government's jurisdiction. The EU Act specifically applies to providers and users of AI systems, including governmental institutions, to the extent this output is produced and used in the EU. AIDA is largely silent on requirements with respect to data governance. In its current form, it only imposes requirements on the use of anonymized data in AI systems, most of which will be determined in future regulation. The EU Act, however, and this is what it's known for, sets the bar very high on data governance. It requires that training, validation, and testing data sets be free from errors and be complete, and that's an actually legally enshrined obligation. So while they both have their broad similarities, it's just impossible for now to predict with certainty how similar they would eventually happen to be, with so much of AIDA still left to be determined. Of course, regulators in both Canada and the EU will aim and might aim for a certain degree of consistency. And since many have likened the EU AI Act to the GDPR, which set global standards to privacy law, the EU law is obviously looked at very closely by people in the field to determine what these tenets will be. Next slide, please. So as I introduced before, the other key piece here is that in addition to proposing AIDA, Bill C-27 also seeks to enact general privacy measures that are relevant to AI. So it reintroduces this CPPA and all of its transparency-related requirements on makers and users of automated decision systems. The CPPA in its current form would require organizations to make available in plain language, so no legalese, a general account of the organization's use of any automated decision system that make prediction, recommendations, or decisions that could have a significant impact on individuals. It would also require organizations that use these systems to provide the affected individuals with an explanation of the decision-making process upon request. These requirements apply to all users of automated decision systems, meaning that AI systems that would not be considered high impact and fall under AIDA would still be required to comply this privacy piece. Next slide, please. So there's obviously a bunch of other key changes to privacy law, some of which I have highlighted here. So to the existing business activity exemption to consent, there's going to be an additional exemption that an organization may collect or use an individual's personal information without knowledge or consent if the purpose of the activity for which the organization collects it for is for a legitimate interest as defined that outweighs the potential adverse effect of the individual subject to certain condition. So it also defines the terms anonymize and clarified that anonymized information is not subject to the CPPA. It clarifies that de-identified information is still personal information, subject to exceptions, but expands the cases in which de-identified information may be used to re-identify an individual. So there's all that nuance there. Organizations are now required to consider the sensitivity of personal information when determining retention periods. So that's also similar to what you see in the GDPR and Quebec's legislation. Security safeguards put in place will now need to include reasonable measures to authenticate the identity of the individual to whom the personal information relates. Organizations are now required, we were talking about retention periods, but they're also required to dispose of personal information, which can include anonymization upon request in certain circumstances. And finally, here I have that while an organization using an automated decision system must, like under Bill C-11, provide an explanation of the system's prediction or recommendation, the circumstances in which such an explanation must be provided are now limited from a privacy angle to those where there could be a significant impact on an individual. Next slide, please. And I would end here with a general note and discussion on contractual considerations, which is at the core of what I do in my practice. So based on our review of the various enacted and yet to be implemented regimes across the world, a major concern for commercial parties will be to ensure that, as always in contracts, there is adequate risk allocation in their and adequate commercial provisions that go with it that ensure that the adequate party is responsible for complying with the regulatory landscape portion applicable to their field of operation. So users of AI systems will want to make sure that any AI technology licensors they deal with have, for example, obtained and secured all required permissions, consent, and usage rights with the data owners of the other other right holders in the data forming part of any licensed AI models to avoid being on the hook as potentially violating parties. Also considering the intertwining and network of applicable legislation, there needs to be a consideration by contracting parties of such compliance, as I was saying, on an international level, as it pertains to their relationship. Adequate audit rights, general diligence will be important to allow parties to demonstrate to each other before a contractual relationship is secured that the required management, reporting, recording, and as we were discussing, transparency obligations are adequately met with companies' internal processes. From a policy and practical standpoint, contracting can, as it has always been and should be viewed as an alternative or at least a complement to other regulatory approaches. Bearing this in mind, parties in commercial relationship with each other are encouraged to include in their terms and contracts elements related to AI systems specifically. To give a concrete example, businesses in Canada, for example, that procure AI-based system may expect the supplier to agree that use rights and data and insights derived from that data will be exclusively for the customer's benefit and his benefit alone. On the other hand, derived data may have significant value for the supplier's future customers that are in similar territories or in similar circumstances. So this conflict between a customer's data rights and the supplier's rights to operate its business ought to be settled early in commercial contracts. Including appropriate provisions in commercial agreements on AI systems would be an opportunity to make some of the soft law that we've been seeing a little harder and on a case-by-case basis. And by the same token, if issues between commercial parties can be settled by agreement alone, this may lessen the need for more heavy-handed legislative intervention as we're currently seeing. Next slide.
Okay, so we are happy to take any questions.
Perfect timing. As folks start to come in, there is one that's first one that's come in talks around a lot that has been covered in relation to ethics, bias, interpretability, still sort of research open questions, especially when it comes to deep learning. Will there be any guidelines or indication on a way to meet the different requirements sort of in these different regulatory acts that you may be able to share some insights?
Yeah, that is a really great question. And I did touch on this for explainability, but obviously that applies to a wide array of other considerations such as bias, right? There's what we would like to see happen in practice and, from an ethical and law point of view, societal point of view, and then there's a technical reality, right? And what is actually possible in the state of AI as it is today, because as we know, it is still evolving a lot. So I will say that we at Mila, we do have a wide component of what we do, which is an academic artificial intelligence research and deep learning research. So we have been really involved with ICED and kind of they've been interested in hearing from us and hearing from the research community and hearing from the technical community to make sure that all the regulation that's going to come out of AIDA is actually going to be adapted to the technical reality. So of course, we'll see how that actually translates in practice and in the text of the regulation. But I am hopeful that the federal government's approach in enacting the regulations around AIDA are really being conducted with a real interest in understanding the technical realities of AI and what's possible, what's not. And so I do think that eventually there will also be guidelines, and then there can be guidelines that are going to be provided, through the government, through the regulations. But also, at the end of the day, when this comes into place, it's really going to be the job of people like me, right, at your organization, people that are in legal functions, to make sure that the technical teams and the machine learning researchers understand what that actually means for them and what they can do to make sure that the AI that they're developing complies with those regulations.
Perfect. And maybe a little bit more sort of around this, specifically around AIDA. So in terms of definitions around the automated decision systems. So for example, if a system generates sort of an output and then that output is reviewed and approved by a human, before it ultimately impacts an individual, would there be potentially some considerations as a semi-automated system and outside of the scope, or is that too soon to speak to?
I can take that one. So automated decision systems is one of those terms that have more meat around it than some of the other elements we've been discussing, like high impact. And the simple answer to that question is that the legislator did consider this. And so automated decision systems are not only the ones that fully automate decision making, but also, as it said, to assist or substantially assist in making recommendations or decisions. So it obviously will be a factual determination, and there will be disputes and probably jurisprudence on that will give additional guidance. But for now, the efforts to define automated decision systems are broader in scope. So it's for things that substantially can help in coming to a final decision.
Yeah, and I do want to add just a quick note on that question. If it's considered not an automated system and therefore be outside the scope of AIDA. So AIDA doesn't only apply to automated AI systems. It applies to AI systems as a whole, but there are specific requirements that apply to automated systems. So just be careful there, because systems that are not automated do still fall under the scope of AIDA. It's just some obligations will not apply to them.
Wonderful. And when you spoke sort of around sort of the data side, around having sort of the consents and licenses to use the data, is there also sort of, a similar consideration when it comes to sort of the weight of a pre-trained model and having those rights and consents? Does it depend on code license or data license or other type things?
I'm glad to take this one. This really comes down, and I see it in the question, it really does come down to the license, either the code license or the data license. of either data sets that you're using, the software that you're using, that's, for example, available on GitHub. Really important to look at the license terms there and make sure that you have the proper. Obviously, we did not really touch on intellectual property matters here because that's not really being addressed by regulation up until now. But the IP piece is a big piece of it, making sure that the license of all of those code or data sets that you're using do comply with what you're trying to do on your end. So for example, for building a commercial product. And then, yes, if there's data sets or pre-trained models that have been trained on personal data, there should be, in the license terms, some considerations of consent around that.
Yeah, and I can add that's also something I do in my practice. When drafting licensing agreements, you will have defined concepts for weights, for hyperparameters, all of these for models, trained models, data. AI contracts are amongst the most complex in that sense because all of these elements can be segregated in a license grant and dealt with individually, whereas in a typical IP license, you would have like background, foreground IP, and just a general grant to it. Here, there's much more nuance. Not every party will choose to have that nuance, but there is this common possibility to address it differently and to create adequate carve-outs in your license to deal with those concepts differently.
Wonderful. And now sort of a question around sort of education, sort of in two pieces. So one, are there education and materials that students could explore that can help them to understand this emerging legal and ethical landscape? And part two, as you sort of think about sort of best resources for one sort of, generally also to stay current on these topics.
I think we would be glad to share some resources, maybe in a post-webinar email that I believe will be sent out. There's a lot going on right now around C27, around AI, around the legal and ethical aspects of it. So there's a lot of conferences like these. A lot of them are free that you can access. There's also more and more educational material. I would say that on the legal and regulatory side, a lot of it has been articles published by law firms, things like that. So maybe a little more on the really legalese aspect, but we are beginning to see some resources that are kind of breaking this down into more practical terms, and we would be glad to share some of that.
Yeah, I was going to say the boring answer, obviously, are legal blogs that we contribute to, but I think they're quite helpful. They're drafted by lawyers for lawyers, but from a general public perspective, and so it does help because because of the great interest. Even now, AI is having a moment more than ever. You do see those updates being published not only when a new piece of legislation comes out, but when some new sense of direction is being given by, like Justine was discussing, a companion paper is published or some comments made by legislature. So you will have little blurbs that are very comprehensive and easy to dive into to see how these things evolve, and that distills these big policy papers or a big piece of legislation into core tenets. So it's a good first dive into these concepts without being overly intimidating for students who just have an interest in it.
Wonderful. And Nikita, yes, as a published author on some of these blogs and things, we'll look forward to some of those links. Before I hand it back to Ben, I just wanted to say also a huge merci to both of you for carving out time to, help to untangle, some of this that is still, very much sort of evolving and helping us to sort of frame this discussion. I really appreciate it. And now, Ben, I'll hand it over to you.
Thank you, Jen, and Nikita and Justine. Thanks again to you both for your time, and thanks to all of our attendees for joining us today. Just a reminder that the resources that were mentioned during the webinar, as well as the recording, will be distributed out in that email. So keep an eye out in your inboxes for that. All right. Thank you so much, and everybody have a great day.
Thank you.
Thank you. Bye.
Thank you.